Well, good evening, everybody. My name is Ave Seltsam. I am the interim executive director for Connected SF and Connected SF Institute. And we are extremely pleased to be joined this evening for a meet and greet with Phoebe Maffei. She is a candidate who is running for seat 16 in San Francisco Superior Court and is on the ballot on the primary in June. So we're thrilled about that. She will run against Alexandra Prey for the seat vacated by current Judge Sandoval, who will not be seeking re-election. Ms. Maffei serves as an assistant district attorney under DA Brooke Jenkins and is known for securing convictions on high-profile cases. And she was one of the successful prosecuting attorneys in the case against Speaker Nancy Pelosi's husband in that terrible attack situation that happened a while back. So without further ado, I would like to introduce Phoebe Maffei.
Thank you so much, Ave, and thank you all so much for having me this evening. Happy to address your questions, give you a brief introduction. My name is Phoebe Maffei. I am running for San Francisco Superior Court Judge in the June election. I'm running for judge because I think San Francisco deserves leaders in our courts who are fair, principled, and grounded in real-world experience. I have spent the last 15 years in public service at the district attorney's office, working in assignments ranging from elder abuse to public corruption. I've handled civil litigation and public integrity cases. I've also handled complex matters involving corporate accountability, corruption in public office, financial exploitation of seniors, and violent crime, always with a focus on fairness, accountability, and protecting our communities. Before law school, I came to California to serve with City Year, believing deeply in community-based service. That commitment to service and community has never left me. I'm running because San Francisco needs judges who combine compassion with common sense and who understand the stakes for real people and who will apply the law without the noise, just fairness and integrity. I believe that public safety is a fundamental right and that well-run courts are essential to ensuring both safety and public trust. And these are values I will bring to my job if I am elected as a judge. I am happy to answer any questions or provide more background information about my work at the DA's office.
Wonderful. And as I just indicated, please feel free to list any questions that you have for Phoebe Maffei in the chat. I know Griff has a couple early questions that he would like to ask. And like I said, Griffin is our community outreach lead. And Griff, I'm going to throw it to you to ask a couple questions.
Awesome. Thanks, Ave. Yeah, to get things going here while you come up with questions, please do put them in the chat as we go. But Phoebe, the first question I had for you is specifically around public safety and community trust. How do you see your role as a partner in public safety for San Francisco residents? And then what is one thing voters may not know about your experience or approach that should give them confidence in your ability to keep communities safe from the bench?
Thank you. I'm making a note because that was a two-parter.
And I can repeat this.
Thank you. I have a goldfish memory sometimes. I might need your help. The role of a judge regarding public safety is really as a backstop. As an assistant district attorney, it has been my job to advocate for victims in support of public safety, but judges really make a lot of the important decisions about who is allowed to be out in the community and who is not allowed to be out in the community. Hopefully, as a judge, you are given all of the information you need to make that decision. The role of the judge is really as a backstop, and a lot of people will often say as sort of an umpire. You're in the courtroom in many circumstances, just calling balls and strikes, making sure that all of the attorneys follow the law, and that the law is being applied to the facts fairly, and that everybody is being given an opportunity to be heard and provide their information to the court. But one of the key roles of the judge and one of the key things that the judge is supposed to consider in making decisions about sentencing and release before a trial when we're dealing with criminal cases, and in family court matters when you're dealing with, who is responsible for caring for children, is public safety and the safety of the community more broadly. And that means lots of different things. It means considering a person's past conduct. It means considering a person's particular needs within the community and how those can be met, whether they can be met outside of an incarceration situation or not. And those are very important to me and things that I will consider as a judge. Something that people might not know about me, and as it relates to my work and public safety, not related to my work in the DA's office, but before I became an attorney, I was a bartender in San Francisco, and I worked in restaurants and bars through college to help pay the bills in college, and that's really what got me through law school. I spent 2 years between college and law school working in restaurants and bars, and that gave me a really good sense of people. I dealt with people on good days and people on bad days. I worked in a number of different kinds of places, dive bars. I worked at the Cliff House before the last renovation. And so I learned a lot about how to read people and how to listen to people. And that, almost more than my legal training, has served me well in the courthouse at the district attorney's office. Being able to listen to people, understand people, and see warning signs when there's danger has been really helpful in my practice in a way that surprised me, frankly.
Very neat. That is something I don't think we would have been able to find online. That you
Probably not.
That's awesome. Out of curiosity, what other bars did you work at outside of the Cliff House?
I worked at Pat O'Shea's, which isn't there anymore, but it used to be on Geary at 3rd. I worked at the Horseshoe Tavern in the Marina. I worked at Pacific Catch in the Marina, the first one. I worked at the Marina Lounge also. I worked at the Boardroom in North Beach. I think that's it. And I did a bunch of catering and things too.
A lot of those names sound familiar.
Yeah, very well-rounded, I have to say.
It was quite a variety. The catering was a lot fancier. The Cliff House was a lot fancier, but probably my least favorite of all the jobs was the Cliff House job, honestly.
Awesome. Switching gears a little bit, recent data shows, and when I say recent data, it was from a Chronicle article not too long ago, a significant proportion of drug court cases also involve mental health components, like mental health diversion. How do you view the role of mental health diversion in the justice system, and how would you balance rehabilitation opportunities with accountability and public safety when making judicial decisions?
I'm going to begin my answer by saying that the canons of judicial ethics prohibit me from making any statements about how I would rule or suggesting how I would rule in particular cases. That said, I can tell you about the work I've done dealing with mental health diversion in particular, and drug court and other alternative courts in San Francisco. When I was assigned to our vulnerable victim unit, handling mostly elder abuse case, physical elder abuse cases, many of my cases came through our mental health courts, both mental health diversion and behavioral health court, which is another program that we have in San Francisco. I think those programs are really important. The application of them, I think, is complicated for the courts and for the litigants, for us in the DA's office. We saw a huge change with there was a change in the legislation and the language of the statute. I can't think exactly of when it happened. Within the last 5 years, they changed the mental health diversion statute so that it no longer is written to require a person seeking diversion to prove that their mental health disorder is related to the criminal conduct underlying. It used to be that the threshold that a defendant needed to meet was to prove that connection. The legislature changed the language of that statute sometime within the last 5 years. Time is hard now after COVID. So that there is no proof requirement on the defense to show that there's any connection between whatever mental health disorder diagnosis they have and the criminal behavior underlying. That is probably one of the reasons we've seen such an uptick in these cases going into mental health diversion. And there are now connections between, like you can do drug court now through mental health diversion. And because the requirements for mental health diversion are so much broader than the requirements for drug court, people are getting into drug court that were not otherwise eligible for drug court, because the drug court has some very strict standards around what kinds of cases can go, what kind of prior history is allowed. Mental health diversion was written specifically as a very broad statute. So the judges making decisions about who is able to go into mental health diversion versus just a straight drug court are not left with a lot of options. If a person has a mental health diagnosis that is qualifying, and there is not evidence that the person may commit a super strike, which is murder, attempted murder, sexual-based offenses, things like that, it can be difficult for a judge to deny mental health diversion. And we've had cases come through recently where judges denying mental health diversion are being overturned by appellate courts because that statute is so incredibly broad. Now, that said, the judge also needs to look at whether a person is amenable to treatment in the community. And in making that decision, a judge can look to whether the person has participated in programming before and how successful they've been in that programming before. If somebody has consistently washed out of programming, that's a factor that a judge can consider in deciding whether or not to send somebody or allow someone to participate in mental health diversion. That was maybe too granular an answer. But I think that the program is really important and can be very successful for people, for the right people. But I think that our resources in San Francisco are stretched really thin. And I think particularly for just mental health diversion alone, it can be difficult to get people the necessary resources through that program for them to be truly successful in mental health diversion. There are other programs, including the behavioral health court, which often requires people to plead guilty before they participate in these programs, that have a little bit more of a backstop that as a district attorney, I have been more inclined to use. So in my work, I have litigated many cases involving mental health diversion. I have agreed to diversion in plenty of cases when it seemed to me that the person was going to be amenable to treatment, that the harm had not been significant, and that as a district attorney, I did not believe that the person was going to be a danger in the community. And I've agreed to mental health diversion in those cases. There have been other cases where I have agreed to behavioral health court, which I just discussed, which requires a plea of guilty and doesn't allow for a dismissal, and requires more rigorous programming. And then there have been many cases where I have litigated vigorously in opposition to mental health diversion for defendants that I believed were a risk to public safety, or were not going to be successful programming, that they were not amenable, they'd already failed out too many times, or had demonstrated just a lack of follow through.
Appreciate the context there and getting granular. Looks like we have a couple questions started in the chat here. We wanted to go to the first one. This is maybe more of a pitch for you. What distinguishes you from other candidates in the race, beyond the obvious? What is a less well-known strength or perspective you bring that voters should consider?
I mean, I already talked about the bartending, which seems sort of silly, but I really do think it is a strength that adds to my ability to manage a courtroom, and manage a space. I've had a lot of different jobs in my life. As a young person, I did all the sort of standard babysitting and things like that, retail work, another public facing job that I think has really supported my ability to work with the public. But my work as a district attorney, I think, particularly prepares me for this job. I have had so many different assignments within the district attorney's office in my career. I haven't handled just the violent crime and sort of your regular street crime that most people are familiar with, but I spent a significant number of years in our white collar unit. In that unit, I handled civil cases, which is unique. I think many of you may know that, I'm applying for the job and I have a criminal background, but I will be assigned wherever the court needs me. So I could end up in a civil court handling civil cases. I could end up in the family court. And the time I spent in our white collar division prepared me well for that work because I was constantly learning new areas of the law, new types of cases. In addition to the consumer protection civil cases, I handled public corruption cases, some that were quite public. I was involved in the investigation and prosecution of Bernie Curran, who was a Department of Building inspector, a DBI inspector who was accused of taking bribes. I prosecuted public integrity cases dealing with law enforcement officers who were charged with crimes. I handled cases within just about every law book you can find, every section. And that has prepared me very well for a position on the bench in a way that I think other candidates might not have had the opportunity.
Very neat. And thanks for that background. Liz asks a couple questions here. First, how do you maintain independence from political or public pressure?
That is one of the reasons I have wanted to move to the bench. And it feels very funny in this moment, engaging in a political election in order to get what I hope will be a non-political job. I am here for the work, not the politics. It's how I felt about my job at the district attorney's office. I have been at the DA's office in 15 years, which means I have seen 5 DAs in my time. I came in as an intern under Kamala. There was an interim when I was hired, David Pfeiffer, who's lovely. People don't know him. He was just an interim guy, but he was great. Then I was here under George, and then Susie, and then Chesa, and now Brooke. And if you follow San Francisco politics at all, you know what a roller coaster that has been. I have been able to just do my job in that time. I didn't quit when things weren't going my way. I just found a way to do my job the right way. All I've ever wanted to do is apply the facts to the law and handle each case fairly. And I have been able to do that, thankfully, despite big swings in the politics around me in the DA's office. I haven't been all that involved in politics, and so I'm not always all that impressed by it. And so I plan to just do the work based on what's in front of me.
Awesome. Like that answer. Not impressed by it. May have to dig in more there later. Liz, you had a second question, and given the setting, happy to have you come off mute if you want to ask your second question. If you're there, Liz. If not, I can read it out for you. Okay, maybe she prefers to stay on mute. The second question from Liz is, what reforms would you support to improve the court system?
I can't answer as to, specific reforms politically or legally. I would like to see better technology in our courtrooms. I had the opportunity to watch portions of a trial in the federal court not too long ago. And even just like simple televisions having better access to media in the courtrooms that they have in the federal courts makes the courtroom more accessible to everybody. It means people who have disabilities and are unable to come into the courtroom have better access to what's happening in the courtroom space. People who can't see or hear as well, if we have better technology in the courtrooms, have better access to what's happening. People who can't make it to the courtroom should have easy Zoom access. There isn't reliable Wi-Fi at 850 Bryant. There's Wi-Fi, but it falls off all the time, and the Zoom goes down, and people who are trying, victims, witnesses, defendant family members, aren't able to access the courtroom proceedings. And we are in San Francisco, and that's frankly embarrassing. That's something I think that's really important. The physical space could use some improvements. I mean, frankly, the building should probably be torn down, but there are lots of things that could be changed there to make accessibility better too. I had lots of victims and witnesses in wheelchairs or with other mobility issues. And all of the locations we have for people to testify in the court are on raised platforms that are often not accessible. So things like that, I think I'd like to see a change physically to the space. And something that's important to me will be being more efficient with our time in the courthouse. I know as an attorney, you will hear people complain all the time about long waits to call cases and deal with things. But I think even more significant is how very long it takes to get a case from beginning to end. And as I understand it from talking with colleagues, that's a problem in civil court and criminal court. As one judge coming in, I can't change the whole system, and I wouldn't expect that I have all the answers either. But that
best candidate is not always the winning candidate.
Apologies about that.
No problem.
If everybody could mute, that would be so helpful, so we can hear what Phoebe Maffei has to say. Peter, would you be willing to go on mute, please?
Sure, sorry.
Thank you. We were listening to some very important information here. So please proceed.
No problem. So anything I can do in my role as a judge to move cases along more quickly, I will be doing. Obviously, I work within the confines of the courts and what they can do. But I think justice delayed, justice delayed is justice denied is something you hear. And I think it's absolutely true. I think it loses its impact for both people accused of crimes and for people who are victims of crime. Everybody ends up feeling sort of like a victim in the end when it takes too long.
Well, I'll give you another question. Given you've been in, your role for so many years and you've seen so many DAs come and go, does anything surprise you anymore? Or are there things that happen that, you just, that surprise you? Because it is, after all, San Francisco. So we always have surprises.
I know. I have to say, walking around San Francisco, I am surprised by things people do every once in a while. And then that surprises me every time. Unfortunately, I am still surprised by how awful people can be. More often, I am surprised and happy to see how wonderful and caring people can be. I always like to see things turn around for somebody. I've always said as a DA that I hope to never see people again. Anybody who's coming into the courtroom as a victim of crime or as somebody accused of crime or as a witness, I hope to never see them in the courthouse again. I hope that things improve for everybody. And people surprise me. They do well. Even when things seem bleak, people can make good turnarounds. And you see weird things on the flip of, sort of far left field. You still see the strangest things. I was walking down the hallway at the Hall of Justice the other day, and there were just 2 eggs on a bench in the Hall of Justice. So there's always something surprising.
Thank you. Griff?
Yeah, maybe I'll repeat it. If anyone has a burning question or something they want to ask Phoebe, happy to. Oh, looks like
a couple more.
Yeah. Peter stated, as you may know, the best candidate doesn't always win. What are the key endorsements you need and fundraising goals you have and outreach to voters in a low turnout race?
Okay. So I am very new to politics and I am still learning. I do know in a down ballot race like this, especially a primary race, I need endorsements are going to be a really big part of it. I have already won the endorsement of the DCCC. And I think that's very helpful, particularly in this race, in this moment in San Francisco. I also have the endorsement of Alice B. Toklas, Democratic Club. I am seeking endorsements from other significant Democratic clubs and many bar associations, which I think help get the word out among lawyers who sometimes care more about this than others. It sort of depends, less than you would think, frankly. I also have endorsements from Assemblymember Catherine Stefani, Congressman Kevin Mullen. A large portion of the Board of Supervisors have already stepped up to endorse me, and I'm still working on other California electeds for endorsements. That is a big portion of where I'm spending my time right now, endorsements and fundraising. My floor for fundraising is around $250,000. I could do a lot more if I can get to $350,000. I expect to be able to meet the floor, but it's taking a lot of work. It's all so new. But I'm getting better at it, and I'm trying to reach a lot of people. I think it's helpful that I've lived in the city for a really long time. I've lived here for 25 years or more. I have good networks within the city, different jobs I've held. I went to USF here in town, so I have school network. I went to Santa Clara for law school, so that's also close, even if not straight here in San Francisco. And my children have been in a number of different San Francisco public schools over the last however many years they've been in school and daycare. At this point, I have a fifth grader is my top. They're in fifth, third, and kinder. So I'm hoping to reach into all of my networks and get my name out. I know this is one where a lot of people just don't vote.
Awesome. And I appreciate
There's another question.
Yep. The next question is, I'm not familiar with the court system in our city, but I know a lot of people are disenchanted with it. I think most of us wish for reform or improvement, but also a lot of us feel justice sometimes favors the perpetrators who committed violent crimes where they don't face consequences. Any thoughts on this? Thank you.
I feel that mood acutely, especially, when I pick juries and I get to talk to people about this specifically. And I know that that's really frustrating for people. And I think this goes back a lot to the system taking a really long time. And it feels like that really inures to the benefit of people accused of crime, because victims wait sometimes years. Often, especially on a homicide case, you can wait a decade for any closure or sense of justice. I also think when you have been a victim of violent crime, it's my experience working with victims that it's really hard to ever feel like a real sense of justice and closure when you have been victimized. We rarely get any kind of why for people. And that is the question I hear the most from victims. Why me? Why did they pick me? Why did this happen? And even in cases with the best outcomes where we get, a significant punishment that's also meeting the needs of the defendant so that there will be change and somebody doesn't just get incarcerated for a short period of time and then come out just as bad or worse. We need to combine punishment and deterrence with rehabilitation. Otherwise, we just make things worse for our community. But I understand that feeling that it seems often that the rights of the accused are taken much more seriously than the rights of victims. I've been an advocate for victims throughout my career, and I understand that frustration and have felt it myself sometimes.
Next is actually a comment from Zach. I have known Phoebe for over 15 years and know her to be a very honest, capable, intelligent attorney in person. I think she would do a fantastic job as a judge in the city.
Thank you, Zach.
And then next question from Brian. The anticipated sentence in the case of the driver responsible for the West Portal accident has generated controversy. The victim's family are reportedly devastated. Can you shed some light on the process of determining a sentence that balances justice for the defendant as well as justice for those impacted by the crime committed or crimes committed?
I can't comment on that specific case, given the parameters of the canons of judicial ethics. But a judge needs to balance. I mean, I just mentioned punishment, deterrence, and rehabilitation. Those are the three considerations. Those are the legal considerations that a judge makes when determining what a sentence is going to be for somebody. And there are a lot of other provisions in the law for what things you are allowed to consider as a judge when determining, where you have to fall on what you're leaning on: punishment, deterrence, or rehabilitation. In theory, all three have to come into play. You have to consider a person's criminal background. They often consider the criminal background of a victim, but more important is the criminal background of the person accused of crime. We consider certainly the impact on a victim and their family. Also, the impact on the greater community comes into play. And then any mitigating factors for the person accused of crime. They have to consider really everything that a person's experienced, what happened on the day of the crime, all of those kinds of things. And it's a hard balancing. It will be a challenge in cases like that is a tragic case. And I think I already said, and if I didn't, I should, that in a lot of these cases, nobody wins. And usually the best outcome leaves everybody a little bit unhappy. You hope that you're able to find a middle ground as a judge where you can serve the public good, ensure public safety, and make sure a victim feels that they have gotten some semblance of justice. But we also have to balance, the circumstances surrounding the person who is accused of crime and what's going on. That's probably not a helpful answer. It's a bit of a non-answer, but unfortunately, that's all the canons allow me to do.
No, it sheds perspective, though. It does.
Next question from Esphere. Santa Clara County District Attorney Office not charging three men who allegedly attacked two Israeli Americans last week for speaking their language and was screaming anti-Semitic insults while beating them, not charging with a hate crime. What would you do in this situation? What would you do in such situation?
Right. And I can't specifically comment on that case. I will say in the vulnerable victim unit, we handled hate crime cases. I did not handle the specific charging of hate crime cases, but I did support my friends in their hate crime work and handle some court appearances on those occasionally. And I will say that the statutory language and the hate crimes makes it difficult to prove those charges. I am not saying I agree with the decision that they made down in Santa Clara. I certainly don't have enough information either way. But I have seen that it's a challenge, and I've seen cases that seem very clear cut. That the person was motivated by hate or bias, and still not seen convictions from juries in those cases. So I don't know why they made their decision there, and I'm not going to comment on that. But I do know that the hate crime statute is written such that it can be very difficult to get a conviction in those cases because you need very specific evidence that shows, outside of just the moment, you often need some other evidence that shows a bias that motivated the crime.
Looks like that's it for the questions in the chat thus far. I think, Avi, if you're open to it, I'd offer it once more. If anyone has a question and can keep it concise, happy to have you come off mute to ask a question live. When we have a bit more time left here.
Okay. Well, I do have to say, oh, did somebody have a question?
Yeah, I'd like to mention that a lot of people are really concerned about what seems to be a very uh, lenient system with the drug dealers in San Francisco. That it seems like a lot of them enter the court system and are just let out either that day or a couple of days later, only to go back to the Tenderloin and start dealing drugs again. And I think that that's one of the main reasons why San Francisco has become a very attractive place for people to come and deal drugs or come to do drugs. And this has had a very serious negative impact on our city in so many different ways. The 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 shoplifting, the two people that die every day because of the drug overdoses, and a lot of it aims right back to the fact that they get let out so easily. And I'd like to know what your response to that is.
Is the opioid epidemic and the situation with narcotics in San Francisco is significant and impossible not to see. My kids ask about it and comment about it when we drive in certain parts of town. Um, the law around whether somebody can be kept in custody has changed significantly over the last several years. When I first started practicing a really long time ago, when people were arrested on even a first offense for narcotic sales, they usually stayed in custody. And they often ended up pleading guilty to the narcotic sales cases pretty quickly and ended up on probation, which meant they had a search condition. And the officers in narcotics who worked in the Tenderloin and the other hotspots in the city knew them and could stop them and take the drugs. And I think that sometimes that helped, and sometimes it probably didn't make too much of a difference. But that's the way it used to be. The laws have changed around when the court is allowed to keep somebody in custody. People v. Humphrey was a decision, again, I have no idea how time works anymore, that came down sometime in the last 5 years. That means unless we are dealing with a violent crime, Article 1, Section 12 of the Constitution, something like that, we are not allowed to keep people in custody unless there is a showing that they are not going to come back to court, or that they are likely to be a danger to the community in some other way. And so I think that's one of the reasons you see, especially first offense narcotics cases, those people are going to get out of custody almost every time, because there is not a legal way to keep them in unless there is something beyond the drug dealing. And then even second time around, I think judges worry about being overturned by the appellate courts based on the language of the law that's come down around who's allowed to be kept in custody and who's not. So I think that's what's happening there. That's the law has been written in such a way that maybe when you get to a third case, you have a better argument for the person's not following court orders. They're not doing as they're supposed to do out in the community. But I think it's challenging for judges to keep people in, even if they think it's a danger to the community or see that as an issue, the way the law is written.
How does that, excuse me real quick, how does that law start the process of potential revision?
Right. This Humphreys is case law, so it hasn't been legislated. That's just decisions of higher courts. And I saw somebody ask why people don't like to be overturned. It creates law. So if you make a decision in court as a judge and it is appealed, which is often the case, especially if you're keeping people in custody, and it goes up to higher courts, our appellate division, even as high as the Supreme Court here in California or onward. When the decision is overturned, that sort of changes the law. That's what happened with People v. Humphrey. And that's a decision where a person had been kept in custody. I forget the specific facts of that case. But the appellate court made a finding, they wrote a whole written opinion that says that it was against that person's constitutional rights. They shouldn't have been kept in custody. They needed to have been released. And so that doesn't get changed without, I guess there could be contrary legislation, but I think it might need like a 2/3 majority to pass or something like that, because it was dealing with a constitutional issue. Sorry, I got granular again.
No, it's very insightful, very, very good information, because, oftentimes the communities don't understand why somebody would be let go.
Right.
And a lot of people feel that, drug use is a precursor to more serious crimes. So
Mhm.
it's just a hard one to understand sometimes, but
It is, and it's something I've found in my work. Is there's knowing something to be true, and then there's being able to prove something to be true, and those are not always the same thing. And that has been difficult for me sometimes in my casework and deciding what cases to charge and what charges I can pursue on a case. Knowing that somebody probably did something is a whole separate thing from being able to prove beyond a reasonable doubt that that person did something. This also goes back to the hate crime question. You may know in your heart that this was a crime that occurred because of somebody's race, religion, sexual orientation, whatever. But just because you know that to be true doesn't mean you can charge the crime or prove the case. And as a district attorney, ethically, we cannot charge any case that we cannot prove beyond a reasonable doubt. As a judge, I won't be charging cases. I'll just be making decisions based on what is presented to me, what the district attorney has already decided, and the information I get from the DA and the defense and any other sources of information I have available to me. But that's something that I try and remember, because the system, even when you know a lot inside the system, it can be frustrating and feel opaque sometimes, even when you're there every day. So it makes a lot of sense that if you're not there every day, it would feel absolutely insane and ridiculous most of the time.
yeah, and I think a lot of people just, don't understand that there are so many complexities to the law, and precedent is a big deal. So,
Yeah.
and, sometimes people just don't understand those components of the law. So it's interesting to hear you address that. I think there's another question, Griff.
Yeah, I think Jane made more of a statement regarding Tony Phillips. Tony Phillips, in the mayor's was one of the suspects in the mayor's bodyguard incident a couple weeks ago. He had 5 other ongoing cases against Phillips in which he failed to appear in court 7 times in the past 10 months. It's still hard for the something person to understand why he was not held.
Yeah, I can't comment on specific cases, excuse me, particularly not ongoing ones. Yeah.
There.
If I could interject, I wonder what you say that it's the law that needs to be looked at seriously, to allow these drug dealers to keep going back to the Tenderloin and keep dealing drugs. I see a lot of other cities in California that are not having this problem. You don't see it in Santa Clara. I don't know how serious it is in San Diego. It doesn't seem to be anywhere near as serious as it is here. San Jose seems like it's a lot cleaner than it is here. Why do we have one version of law here that allows drug dealers to keep dealing drugs, and down there they don't have a problem anywhere near as the one we have here?
Yeah, I don't know. I've wondered that myself. And I don't know, because the law is the same across the state. But I only live here. And so I only see what's happening here. I don't know what the situation really is like on the streets in those other cities. And I'm not necessarily advocating for a change to the law, and I don't even know what direction you would go on that. Just making a comment, political will, making a comment as to my observations about the law.
Are there any other questions? Okay, well, Phoebe, if you just wanted to give some closing remarks, and we can just conclude the program.
Sure. Thank you so much. I really appreciate everybody's time today. I started out telling you a little bit about my background, and my story really is rooted in service and community here in San Francisco. I grew up all over this country, but I came to California more than 25 years ago to serve with City Year. It's a domestic Peace Corps program here in the Bay Area. And I did that because I believe in giving back to my community. After college at USF, I mentioned that I worked in restaurants and bars around the city, but public service really called me back. And I went to law school to become a prosecutor. After 15 years, I have stood up for victims. I have protected seniors from exploitation. I have prosecuted public corruption and worked to ensure accountability at every level here in San Francisco. I have seen people on the worst days of their lives, victims seeking justice, families in crisis, individuals facing real consequences. And I have approached every case with both compassion and a sense of responsibility. I'm also a mom to 3 young girls, as I said, here in the San Francisco public schools, juggling school drop-offs, homework, and occasionally carving out a little time for myself in day-to-day life. I live the same daily realities as most San Francisco or many San Francisco families. I'm running for office because I believe public safety is a fundamental right, because our most vulnerable residents deserve protection, and because our courts must be fair and efficient and grounded in common sense. If elected, I would be a judge who listens to people, who leads with the values of law and justice, and who works every day to earn the public's trust. And I hope I will have your support. Thank you so much for all of your questions tonight, and for taking this time out of your busy evenings to talk with me.
Well, we too are very grateful that you took the time out to speak with us. And I just want to also a little note of appreciation to everybody on the call for their excellent questions. Very good questions, actually. So I really appreciate that. I know we all do. Griff, thank you for manning the Zoom technical aspects of this call this evening. But we are absolutely thrilled that you took the time out to address our group and to answer our questions. So thank you to everybody and have a nice evening.
Thank you so much.